Indistinctly applicable measures under the EU law. One of the chief goals of the EU is to achieve a single market where there will be free movement of merchandise within the member states. Free movement of goods will promote competition and result in price advantage and quality of the product to the EU consumers. There exist two obstacles to the free movement of products within the EU. This pertains to the interpretation of ECJ on the common provisions of technical restrictions under Article 28 of the EC Treaty. The second barrier is the immunity to the general provisions of Article 29, Article 28 footed on Article 30, and the compulsory needs emanating from the decision in the Casus de Dijon by the ECJ. Article 28 deals with quantitative restrictions, QR. If a member state announces a complete ban or quotas, then they will infringe Article 28 of the EU, and this can be saved only by reference to Article 30 derogation. Article 28 also deals with measures having an equivalent impact to quantitative restrictions, MEE, on merchandise, which includes content, shape, labeling, composition, and identification that applies to both domestic and imported products. Casus de Dijon's verdict is a landmark one as it has offered the required legal mechanism to make sure that there exists a free trade in merchandise in the EU. It has facilitated the trading community to challenge any endeavor to limit their commercial freedom on the footing of national measure. The Casus case has made the ambit of Article 28 without limit as it restricts all national rules obstructing intra-EU trade, which includes both marketing and product specification. In GIB Group versus Confédération du Commerce Luxembourgeois, it was held by ECJ that free movement of merchandise within the EU is the legitimate right of not only traders but also consumers who can travel freely to another member state and can shop for such products for their use. In Dassenville's case, it was held that all commercial regulations enacted by the member states that impede trade between two member states either directly or indirectly will be regarded as analogues to quantitative restrictions. In Casus de Dijon, it was affirmed by ECJ that the doctrine of reciprocal recognition of the national law and the privileges of consumers to benefit from the free movement of merchandise. The ECJ, in its ruling, has said that if merchandise fulfills the rules of one EC member state, then such regulations should be honored by another member state as functional equivalent. Under the Dassenville formula, there should be equal treatment of domestic and imported products. If there is prejudice between them, then the principle of Casus de Dijon will not be applicable, but the Dassenville formula will be. Thus, the Casus de Dijon formula is more concerned with indistinctly applicable rules and the Dassenville formula is concerned with distinctly applicable rules. This was corroborated in the case Commissioner versus Ireland, and again affirmed in the case Schutzverband gegen Anwesen in der Wirtschaft versus Weinvertriebs Limited Liability Company. The likelihood that Article 28 could be extended to indistinctly applicable rules was evident in Dassenville, and the characterization of a MEQR in Para 5 did not demand a measure to be biased. Thus, the initiation that was taken in Dassenville and Directive 7050 came to reality in the decisive Casus de Dijon case. The Directive 7050 is so crucial as Article 2 is dealing with discriminatory measures and Article 34 is dealing with the marketing of merchandise, which includes size, shape, presentation, composition, and identification that applies to both domestic and imported products, and where any restrictive measures on imported products surpass the effects fundamental to such regulations. Thus, what started as an affirmation of states' privileges was later translated into a legal verdict that demanded the state to substantiate the indistinctly applicable rules under the rule of rationale. ECJ has inferred Article 30 strictly mainly to make sure biased restraints on the free movement of merchandise will not easily be substantiated. However, there exist hardships regarding the relationship between defenses to indistinctly applicable rules and discrimination. The association between the exceptions in Casus and Article 30 has become further problematical by dividing the line between issues relating to indistinctly applicable rules and indirect discrimination. In Commission v. Austria, it was contended whether the rule should be considered as discriminatory or indirectly or indistinctly applicable, and it was held by ECJ that the Austrian rule was indistinctly applicable and hence safeguarding measures for the environment could constitute an objective excuse to the rule. In its decisive verdict on Article 28 EC, Article 34 TFEU, in Dasonville, it was ruled by ECJ that all trading rules made by the member states that hinder or hamper the movement of merchandise within the EU will be considered to be analogues to quantitative restrictions. However, in the same case, ECJ acknowledged that rational initiatives of analog effect would be attuned with Article 28, Article 34 TFEU. Thus, whenever there is an issue of national importance like the environment, ECJ has affirmed that there could be an objective exception to the discriminatory rule, and in such cases, ECJ may apply indistinctly applicable rules.